Thank you, Madam President. It's a great honor to appear before the court and to do so on behalf of the Republic of Armenia. I will be addressing the facts relating to the inhuman and degrading treatment of and the failure to repatriate the prisoners of war and civilian detainees of Armenian ethnic origin. Thereafter, I will demonstrate the plausibility of that such conduct is a denial of rights and obligations arising under the CERD. As noted by Armenia's agent, on 27 September 2020, an international armed conflict broke out in Nagorno-Karabakh. Most of the fighting occurred over the next 44 days, at which point a ceasefire was reached on 10 November, brought about by the trilateral statement of Armenia, Azerbaijan, and Russia. Yet sporadic troop movements, encounters, and armed incidents continued thereafter, including during a period when Russian peacekeeping troops were being deployed. Azerbaijan is obligated to repatriate all POWs and protected civilians under international humanitarian law, human rights law, and the trilateral statement, which provides that the parties shall exchange prisoners of war, hostages, and other detained persons and bodies of the dead. Yet Azerbaijan continues to detain 42 Armenian POWs and 3 Armenian civilians in violation of their rights under the CERD, including to equality before the law. And to be clear, the fact that Azerbaijan is detaining these 45 individuals is not in dispute. A list of their names and other information is in your judge's folder at tab 3. These are specific people. They have names, they have faces, and they have families. The first 2 POWs are Armenian members of the Mobilization Reserve of the Armenian Army. The first of these 2, named Alosha Kosovan, was captured in early October 2020 in Artsakh. The second POW, Ludwig Makurchkin, was captured on 20 October 2020 in Fuzilay district of Artsakh. Thereafter, the list contains 38 POWs who appear as numbers 3 to 40 on the list. These POWs are Armenian soldiers captured on 13 December 2020 by Azerbaijani Special Armed Forces near the villages of Hintagir and Kurtsaberg, which are in the Hadrat region of the Republic of Artsakh. The 2 villages and surrounding territories were not among the territories from which Armenian troops were required to withdraw under the trilateral statement. Rather, this is an area where the forces of both sides were to remain at their current positions, and then along the line of contact, there was to be deployed Russian peacekeepers. As of 12 December, Russian peacekeepers had not yet fully deployed along this part of the line of contact. However, after this incident occurred on 13 December, Russian peacekeepers raced down to this area of Nagorno-Karabakh. On your screen is a Russian map dated 13 December 2020 with Armenia's translations into English. From this map, you can see the Russian peacekeeping zone, encircled by a thick blue line, which includes at the very bottom of the zone, the village of Hintajr. The village of Kurtzeberd is not visible on this map, but it is less than 10 kilometers northwest from Hintajr, and hence it is also in the zone. Thus, in the aftermath of the ceasefire, and while the peacekeeping forces were being deployed along the line of contact between the two belligerent military forces, Azerbaijan launched a military operation that captured 62 Armenian soldiers, known as the Kurtzeberd Group. Of those 62 POWs, 24 have been repatriated, but 38 remain detained by Azerbaijan. Two further POWs, who appear as numbers 41 and 42 on the list, are Armenian soldiers captured on 27 May 2021. On that day, Azerbaijan surrounded and captured 6 Armenian soldiers near Kut village in the Gagarkakunik region of Armenia, where they were engaged in engineering work. Although these soldiers were not in Azerbaijan, Azerbaijan alleges that they had tried to carry out sabotage and reconnaissance operation and sabotage terrorist activities in Azerbaijan aimed at planting landmines in the roads. 4 of the 6 soldiers were part of a group of 15 POWs repatriated to Armenia on 12 June 2021. But 2 less fortunate soldiers from this same group, Ishkan Sargsyan and Vladimir Rafaelian, remain POWs. Finally, Azerbaijan has acknowledged that it continues to detain 3 Armenian civilians who appear on page 9 of your list. These civilians are protected under the 4th Geneva Convention. The first civilian, an Armenian-Lebanese dual national named Vikin Yuljekshian, was detained on 10 November 2020 by Azerbaijani armed forces while he was driving to collect personal belongings in Shushi before returning to Armenia. The other 2 civilians, named Gevorg Sezhian and David Davitin, were detained on 11 November 2020. They are employed by a non-governmental charitable organization that conducts humanitarian activities for the civilian population who are affected by the conflict. These 2 civilians were detained during a humanitarian mission while driving along the Goris-Stepanakert highway. Madam President, separate from these 45 POWs and protected civilians, there are dozens of Armenians believed to be in Azerbaijani's custody, but Azerbaijan has failed to acknowledge them, despite direct evidence of their capture. Such evidence includes testimonies of former POWs and civilian detainees, as well as videos and photographic images showing them being held captive. As far as Armenia is aware, neither their families nor the ICRC have information on their whereabouts or whether they are still alive. Efforts before the European Court of Human Rights to obtain information and release of such persons have resulted in a series of interim measure decisions of protection by that court, which inter alia called upon Azerbaijan to provide information on these individuals. But as that court noted in December 2020, the Azerbaijani government has frequently failed to provide the information requested by the court, prompting a referral of the matter in March 2021 to the Council of Europe's Committee of Ministers. Ultimately, whether the persons have been acknowledged or not, the Strasbourg Court, as a rule, does not issue interim measures ordering the release of detainees in such circumstances. Madam President, there is an overwhelming body of evidence indicating that every one of the 45 acknowledged detainees and a large number of other detainees have been subjected to torture, degrading treatment, and other abuse by Azerbaijan. Indeed, there are numerous corroborated reports by independent organizations that the POWs and civilian detainees have been exposed to stabbings, beatings, burnings, and electric shocks. Such treatment is often accompanied by ethnic slurs and other hate speech. While Azerbaijan has sought to hide such treatment, it is readily apparent from the consistent and credible reports by POWs and civilian detainees who have been allowed to return to Armenia. Members of the court, the documentary evidence is shocking enough. But there is also, among this body of evidence, a large number of videos that we have submitted to you where the court can see with its own eyes the horrific abuse. You'll find the reference pages for those videos in your judge's folder at tab 4. These videos were posted on social media by Azerbaijani servicemen or others and were then picked up by news sources. For some of these videos, we added English subtitles so that the court may understand what is being said. I anticipate that you will find these videos deeply disturbing, not only from the atrocious acts being committed, but in the clear hatred being shown to persons of Armenian origin. Tragically, it's well known that a number of military and civilian detainees of Armenian origin have not just been inhumanely treated, they've also been executed. These executions are also evidenced by witness accounts and other information. And these executions are also evidenced by videos that we've submitted to the court. Here, too, the court will find these execution videos shocking, graphic, reprehensible, and riddled with hate speech. And sadly, even in death, the abuse continues, as there are also numerous videos of the bodies of deceased Armenian soldiers being mutilated by Azerbaijani soldiers, done in conjunction with hateful slurs against the Armenian people. We urge you to review these videos as you consider the fate of the 45 acknowledged detainees and of those detainees who have not been acknowledged. But to highlight how the suffering seen in these videos directly connects to the current detainees, I wish to describe one of the videos, which is found at Armenia's Annex 69. This video demonstrates the suffering of one of the acknowledged POWs, Ludwig Mkrtchyan, who is the second POW listed in tab 3 of your folders. In the video, which may have been taken shortly after Mkrtchyan and other Armenian soldiers were taken captive, you will see Mkrtchyan lying on the ground along with the other POWs. Mkrtchyan has a bullet wound in his left hip and tailbone. Despite that wound, he is blindfolded and he is restrained. He is clearly hors de combat, yet his Azerbaijani captors kick him in the back, they step on his head, and they poke him with a sharp rod. One of his captors asks, "Where is his finger? Shall I cut it?" Mkrtchyan begs not to be harmed. He says, and I quote, "Don't shoot. Please, don't kill me." In the video, the other Armenian POWs fare no better with such treatment. The Azerbaijani soldiers also step on them, kick them, poke them with the sharp rod. These POWs, as you will see, are clearly afraid. One of the POWs begs not to be harmed. One of the captors responds with hateful language. He says, and I quote, "You're going to keep on begging like this a lot. You, the disgraceful people, pimps, faggots." Towards the end of the video, one of the captors says about one of the POWs, "Cut it, cut the finger." Another captor approaches that POW with a sharp metal rod. As the POW, blindfolded, bound, and prostrate, begs not to be touched, the captor then places the sharp rod against the POW's fingers and then pulls back just before the video ends. I note that the corroboration of this abuse, and specifically of Mkrtchyan, can be found in other videos that we have provided to the court. Members of the court, we submit that there's an ample basis for the court to conclude in this proceeding, as it did in the Tehran hostages case, that continuance of the situation, the subject of the present request, exposes the human beings concerned to privation, hardship, anguish, and even danger to life and health, and thus a serious possibility of irreparable harm. Another form of this abusive treatment bears noting. Azerbaijan has subjected these detainees to sham criminal proceedings in which individuals are charged long after they should have been repatriated and then tried and convicted in a matter of days, often in a language they do not understand. These convictions were typically based on charges that are not triable under the laws of war. For example, it makes no sense in the context of a ceasefire agreement that leaves armed forces positioned in places opposite each other for one side to charge the soldiers of the other side with illegal border crossing and illegal carrying of firearms. Likewise, it makes no sense to convict someone as a mercenary when he is a national of one of the belligerents. The 2 POWs captured in October 2020 were convicted for acts that allegedly occurred 3 decades ago, which at the time were never pursued by Azerbaijani authorities, and in any event were overtaken by the obligation to repatriate. Moreover, some of these convictions apparently were based on confessions, yet there is ample evidence of Azerbaijan coercing confessions through torture. The court simply cannot countenance a justification for detaining POWs and civilians that is tainted by such conduct. That these criminal proceedings are a sham is also demonstrated by the fact that Azerbaijan blithely releases some of these so-called criminals whenever it is able to extract something from Armenia in exchange. As I previously noted, 6 POWs were captured on May 27th of this year. Azerbaijan rushed to charge them with crimes on 28 and 29 May. Then, just 2 weeks later, on 12 June, 4 of those POWs were released as part of a group of 15 Armenian POWs. Why release POWs who are allegedly criminals? Well, they were released by Azerbaijan so long as Armenia provided a map detailing the location of mines in Agdam. Such conduct is arbitrary, and it speaks volumes about the nature of Azerbaijan's so-called criminal proceedings. Indeed, similarly, Azerbaijan charged a group of Armenian POWs with the crime of illegally crossing the border, and on 2 July 2021, sentenced them to prison. Yet the very next day, on 3 July, Azerbaijan released 12 of them as part of a group of 15 POWs, this time in exchange for maps of mines in the Fuzulay and Zangala regions. The 3 others in this group still had their trials pending, yet they too were repatriated. The arbitrariness of Azerbaijan's so-called criminal proceedings continues in that all 15 of those released POWs were from the Kurtzaberd group, yet many others from that same group remain detained. Hence, the fact that the continued detention of the POWs has nothing to do with actual criminality is readily apparent from Azerbaijan's willingness to repatriate some POWs on some occasions whenever Azerbaijan believes it has extracted something from Armenia, while refusing to repatriate other POWs who were captured for the same acts and at the same time and in the same place. This is not a situation of applying criminal law fairly and judiciously. It's using criminal law arbitrarily as a subterfuge for prohibited discriminatory conduct. Finally, on the factual discussion, while it's reported that Azerbaijan is allowing the ICRC to visit these 45 detainees, There is also evidence that Azerbaijan is seeking to hide the other detainees and to hide its abuse of all the detainees from the ICRC and from others, making their repatriation all the more urgent. For example, the rapporteur for the Parliamentary Assembly of the Council of Europe was repeatedly denied permission to visit these detainees. I turn now to the plausibility of the rights at issue. Azerbaijan has an obligation to repatriate the POWs. Indeed, this is one of the most important obligations of international humanitarian law. Azerbaijan's disregard of that obligation is ethnic discrimination, pure and simple. Whereas virtually every other country in the world takes quite seriously the general obligation to repatriate all POWs after the cessation of hostility, Azerbaijan has not, because of its policy of hatred toward persons of Armenian ethnicity. As was apparent from the presentation of Mr. Salonides, persons of Armenian ethnicity are viewed by the Azerbaijan government as subhuman, as meriting a disgraceful and demeaning trophy park, but as not meriting the fundamental right of repatriation. For Azerbaijan, the POW's value is not to be found in human dignity. Rather, their value is as a bargaining chip. They are pawns for Azerbaijan to advance its political interests, an especially pernicious exercise of ethnic discrimination. Article 1, paragraph 1 of the CERD defines racial discrimination in broad terms to include any distinction, exclusion, restriction, or preference based on race, color, descent, or national ethnic origin. Thus, restrictions based on ethnic origin are a form of racial discrimination. Article 2 then obligates states parties not to engage in any act or practice of racial discrimination against persons or groups of persons. 5 furthers the fundamental obligations set out in Article 2 by making clear that, and I quote, states parties undertake to prohibit and eliminate racial discrimination in all its forms and to guarantee the right to everyone without distinction as to ethnic origin to equality before the law. Equality before the law. Moreover, Article 5, subparagraph D2 specifically protects the right to leave any country and to return to one's country. We submit that it is much more than just plausible that these rights under the CERD are being denied to the POWs. The government of Azerbaijan has directly ordered their continued detention. There's no issue of private action here. This failure to repatriate is a denial to persons of Armenian origin of their rights under the CERD to equality before the law. In this instance, before or under international humanitarian law. Azerbaijan may not, under the Third Geneva Convention, refuse to repatriate these POWs. Many organizations and observers have already reached that conclusion on the merits. Indeed, the Third Geneva Convention itself prohibits racial discrimination against POWs. When one considers the general background of Azerbaijan's hateful views regarding persons of Armenian origin, along with the inhuman and degrading treatment of these POWs, and along with the occasional use of the POWs as bargaining chips. All such circumstances strongly demonstrate that this failure to repatriate is not just plausibly racial discrimination, it is racial discrimination in the form of a denial of equality under international humanitarian law. Now, you may hear from Azerbaijan this afternoon that all these POWs are criminals and that their detention has nothing to do with ethnic discrimination. Yet all the evidence points towards ethnic discrimination, and no one is accepting Azerbaijan's claim of criminality. UN human rights experts don't accept it. The European Parliament does not accept it. The Parliamentary Assembly of the Council of Europe and its rapporteur do not accept it. Rather, all of them have called for the expeditious repatriation of these POWs, as have many governments. Time does not allow me to describe in depth the plausibility of the POW's rights under the CERD not to be beaten, tortured, or otherwise physically or mentally abused. But here, too, we submit that it is much more than just plausible that such treatment violates CERD Articles 2 and 5, and in particular Article 5, subparagraph B, which protects the right to security of person and protection by the states against violence or bodily harm. The POW's treatment before Azerbaijani courts also clearly implicates CERD Article 5, subparagraph A, which recognizes the right of equal treatment before the tribunals and all other organs administering justice. And the overarching Article 5 right to equality before the law is further implicated given that Azerbaijan's inhuman and degrading treatment is a denial to an ethnic group of their rights under international humanitarian law and also under international human rights law, including prohibitions on arbitrary detention, on torture, on inhuman and degrading treatment, and as well as the freedom to leave any country and the right to a fair trial. As is the case with the POWs, it is more than plausible to maintain that the government of Azerbaijan's refusal to repatriate the 3 acknowledged civilians is a denial to persons of Armenian origin of their rights under CERD Articles 2 and 5 to equality under the law, including the security of their person and to the right to return to their country. And with respect to the equality under the law, Azerbaijan simply has no basis under either the 4th Geneva Convention or human rights law to refuse to repatriate these civilians or to treat them inhumanely. Again, many organizations and observers have already reached that conclusion on the merits. Under the 4th Geneva Convention, civilians are protected persons. And if interned during the conflict, they must be released after the cessation of hostilities. They must be treated humanely, without any distinction founded on race. They must be protected from murder, torture, or brutality. The taking of civilians as hostages is forbidden, and they shall not be deprived of the rights of a fair and regular trial as prescribed by the Convention. And similar protections for these civilians arise under the previously noted human rights law. Madam President, the plausibility of the rights claimed under the CERD with respect to POWs and civilians that Azerbaijan has not acknowledged, but has also treated inhumanely and has not repatriated, also flows from what I just said. Although these persons are not acknowledged by Azerbaijan, There is ample evidence that they were taken into captivity, that they have been abused, and obviously that they have not yet been repatriated. For the reasons previously indicated, it is more than plausible to regard their treatment as a denial to persons of Armenian origin of their rights under Articles 2 and 5 of the CERD, notably their rights to equality under the law, to return to their country, and to the security of their person. Madam President, that concludes my presentation.